I'm attorney Eric Johnson, and this video discusses, in as few minutes as I possibly can, the most comprehensive overview on child custody in Utah that I can provide. Now, as with all material on this website, including this video, the information on this page is not a substitute for legal advice from an attorney who meets with you about your personal child custody and parent time issues. The stakes are so high and the law so counterintuitive in so many ways that the most efficient use of your time would be meeting in person with an attorney about your specific case. This is a subject that is too important not to. Now, child custody, as it's disputed, can be resolved in one of two ways. It can be either resolved by an agreement or by a judge when the parents can't agree. Keep in mind that almost 9 out of 10 people agree on what it is they're going to do with their children, and it's really only a small segment of people that actually end up with a judge deciding child custody in a courtroom. Yet people spend most of their energy worrying about what would happen in court, and not as much energy at all thinking about what they can do to get the issue resolved by agreement. An agreement needs to be your focus. That's the way most people work this issue out. A lot of people think that child custody means only one thing: which parent the children live with. While that's a major component of child custody, the term child custody encompasses a lot more. Custody of minor children means the legal status awarded by the court for the care, control, and maintenance of that child. In Utah, child custody can be brought as a separate case or as part of a divorce case or a separate maintenance case, a temporary separation case, and many other kinds of cases that don't have anything to do with divorce. We're just going to talk in this video about child custody issues that arise in divorce cases. Child custody in divorce is governed by the sections in the Utah Code that deal specifically with divorce. The overwhelming majority of custody orders in divorce cases award custody of the couple's children to one or both parents of the minor child. However, a custody order may award custody to another adult, like a grandparent or an aunt or an uncle, or even a concerned adult in the child's life. There are two parts to child custody: physical custody and legal custody. Physical custody means where the children live during this year. Now, let's talk about legal custody first. Legal custody is the rights, privileges, duties, authority, and powers of a parent or parents to make specific decisions. Utah permits several different kinds of custody arrangements for minor children. These include sole legal custody or joint legal custody and split legal custody of children. If one parent is awarded the sole legal custody of children, that means that one parent has all the power to make all decisions regarding the child's residence, the child's health, education, moral and religious upbringing, and general welfare. All of those are wrapped up into legal custody. Legal custody is the power to make decisions about major issues affecting the children. They may include, among others, what religion, if any, the child will be raised in, whether the child should receive medical treatment or undergo a major medical procedure, where the child will go to school, or permission to get a tattoo, pierced ears, to get married, or join the military before age 18. The parent who is not awarded legal custody or joint legal custody is considered to be the non-custodial parent. No matter how much this parent may want to be involved in making decisions for the children, if the court has not awarded joint legal custody, that parent has no input in decisions regarding the children other than what his ex or her ex-spouse will provide. Awards of sole legal custody are rare, unless there is domestic violence in the family, or a child has special needs that one parent can meet better than another, or the parents live far apart, or some other factor the court considers compelling enough to award legal custody to just one parent. The presumption in Utah is that it is in the children's best interest for both parents to be awarded joint legal custody of their children. This presumption can be overcome by evidence that would show joint legal custody would be contrary to the children's best interest. So, other than exceptional situations, most divorcing couples will be awarded joint legal custody of their children, meaning that they will continue to share the same equal rights and authority to make decisions for their children without either parent losing those rights or having those rights curtailed. Sometimes, not usually, but sometimes parents find it useful to award exclusive power to make certain decisions for the children to just one parent. They might agree, for example, that the mother has the right to make medical and health care decisions and the father has the right to make educational decisions. That usually ends up, in my opinion, causing more problems than it solves, but it is an option. That's all I will say on the subject of legal custody, because frankly, arguments over legal custody don't arise all that often. Actually, there is one last thing I need to say about legal custody. The legal custody award does not affect the children's residence. Which parent the children live with is known as physical custody. What can get the most contentious in divorce when it comes to child custody is usually physical custody. Physical custody means which parent the children live with annually and what percentage of the time the children live with each parent annually. Utah permits a variety of different physical custody arrangements for minor children: sole custody of the children, joint custody, and split custody. Sole physical custody means the child stays with one parent such that the other parent has 110 or fewer overnights each year with the children. Either parent can be awarded the sole physical custody of the children. Sole custody does not mean that the other parent gets no time with the children. When sole physical custody is awarded to one parent, the other parent is referred to as the non-custodial parent. The court may inquire of the children and take into consideration the children's desires regarding future custody or parent time schedules, but their expressed desires are not controlling on the court. The court may determine the children's custody or parent time other than the way the children desire it. The desires of a child 14 years of age or older are given additional weight, but it is not the single controlling factor in the custody award. The portion of the year that the children spend with the non-custodial parent is known as parent time, and what used to be called visitation. Parent time means the time the non-custodial parent spends with a child. It can also refer to the schedule the parents follow to divide between them the holidays and summer vacation time the children spend with each parent. The court can order any schedule that is appropriate for the children and the parents and in the children's best interest. The Utah Code provides suggested minimum parent time schedules based upon how old the children are. Judges use these schedules frequently but are not required to use them. Judges can order a schedule they feel is appropriate. There are both separate articles and video on these subjects on this page that you'll want to review. What will parent time schedules look like? While it can vary from case to case and judge to judge, Utah has what are called statutory guidelines for minimum parent time schedules where there is a custodial and non-custodial parent. That schedule, found in Utah Code Section 30-3-35 for children 5 years of age and older, is an alternating weekend arrangement where the custodial parent will have the children Monday through Friday, and then the non-custodial parent will get the kids Friday evening until Sunday evening. In the next alternating week, the custodial parent will have the children Monday through Friday and through the weekend. In other words, the non-custodial parent gets alternating weekends, which means every other weekend from Friday to Sunday. The non-custodial parent also gets one 3-hour period with the children each week from 5:30 to 8:30 p.m. under the minimum guidelines. This is known as a midweek parent time period, and that occurs every week, not every other week. Unless the parents or the court specify a different day, midweek parent time occurs on Wednesday. There are many other parent time schedules, including schedules for children under the age of 5 and schedules for non-custodial parents who are able to exercise more than a few hours or a few days every other week or weekend. You'll want to read about those in Utah Code Sections 30-3-35.1 and 30-3-35.5. Each parent time schedule very much depends on the facts of each particular case and the perspective of your judge. Your parent time schedule also includes alternating holidays. In other words, the major holidays of each year are shared by the parents by alternating them in even and odd numbered years. So if you celebrate Thanksgiving or President's Day with the kids this year, your ex will get to have Thanksgiving with the children next year. For those of you who panic about not seeing your kids over Christmas, the statutory guidelines split Christmas vacation from school in half so that both parents can spend a portion of the Christmas break with their kids. For a complete list of the alternating holidays provided for in Utah's minimum statutory parent time schedule, go to Utah Code Section 30-3-35. The parent time schedule also provides summer vacation from school between the parents. Because the children are not in school during summer vacation, courts frequently give the non-custodial parent extra time with the children overnight above what the schedule is like during the school year. It is not unusual for non-custodial parents to get half of the time the children are out of school. Some judges will give the non-custodial parent time as little as 4 weeks. If you and your ex share joint physical custody of your children, you will still likely follow an alternating holiday schedule to ensure the children get to spend holidays and make memories with their parents in a way that fairly divides those opportunities between both parents. All right, let's move on to discussing joint physical custody. Joint physical custody means that the child stays with each parent overnight for more than 30% of the year and that both parents contribute to the expenses of the child in addition to paying child support. Joint physical custody can mean equal or nearly equal periods of physical custody and access to the child by each of the parents. For practical reasons, joint physical custody works best when both parents live in the same general area. Joint physical custody is becoming more and more common in Utah as more mothers enter the workforce and no longer stay at home, and as more fathers take on child caretaking roles and/or work from home themselves. Split custody means that each parent is awarded the sole physical custody of at least one of the children when the parents have more than one child. Legal custody of the children by the non-custodial parent may or may not be shared as ordered by the court in that situation. The child custody award, if made by the court, is based upon what the court perceives as the child's best interest. You'll hear that term, best interest of the child, used a lot when addressing issues of legal and physical custody of the children. When there are disputes about custody, then the court will order the custody arrangement that it feels is in the child's best interest. The court can consider many different factors to determine a child custody award in the child's best interest. These factors are listed in the Utah Code, and I'll describe many of them in this video, but remember, this isn't a complete list. Some of these factors might not be relevant in your case, and there might be other factors relevant in your case that I don't even cover here. For a complete list of the factors, you'll want to read the articles on this page that cover all the child custody award factors. Generally, if the parents can't agree on a child custody award, the court will consider each parent's conduct and moral standards, which parent is more likely to act in the child's best interest, which parent is more likely to allow the child frequent and continuing contact with the other parent, and the depth and quality and nature of the relationship between a parent and child. The court will also consider any other factors the judge deems relevant. Other factors the court can consider in determining whether the best interest of a child will be best served by ordering sole or joint legal or physical custody, or whether joint custody will benefit the child's physical, psychological, and emotional needs, or the child's development. The parent's ability to give first priority to the child's welfare and reach shared decisions in the child's best interest, whether each parent is capable of encouraging and accepting a positive relationship between the child and the other parent, including the sharing of love, affection, and contact between the child and the other parent. The court also considers whether both parents participated in raising the child before the divorce, the distance between the parents' homes, the parents' maturity, and their willingness and ability to protect the child from conflict that may arise between the parents, the parents' ability to cooperate with each other and make decisions jointly, any history or potential for child abuse, spouse abuse, or kidnapping, and any other factors the court finds relevant. While a judge can ask a child which parent the child wants to live with, that rarely occurs, and when it does, it's when the children are sufficiently old enough to hold a meaningful conversation with the judge. And the desires of a child, regardless of age, are not controlling. The court may determine custody contrary to the child's desires. You cannot get joint legal custody or joint physical custody awarded, even if the court wants to award it to you, unless you file what is called a parenting plan with your divorce pleadings. The objectives of a parenting plan are to provide for the child's physical care, maintain the child's emotional stability, provide for the child's changing needs as the child grows and matures in a way that minimizes the need for future modifications to the parenting plan, to set forth the authority and responsibilities of each parent with respect to the child, minimize the child's exposure to harmful parental conflict, encourage the parents to meet the responsibilities to their minor children through agreements in the parenting plan rather than relying on judicial intervention. They are supposed to contain provisions for resolution of future disputes between the parents, allocate decision-making authority between the parents, contain residential provisions for the child, and provisions addressing notice of parent time responsibilities in the event of the relocation of either party. It also is to protect the best interest of the child. Now that's a lot to ask of a bunch of words on a piece of paper, yet the law in the state of Utah is clear. Unless you file a proposed parenting plan, the court cannot and will not award joint legal and/or joint physical custody. So filing a parenting plan is crucial, even if the plan itself may not have that much of an influence over parenting itself. And remember, you and your spouse don't have to file competing parenting plans. If you and your spouse can agree upon the terms of the parenting plan and submit that to the court will accept an agreement between the parents as to the terms of their parenting plan in almost every case. The court order may govern custody and parent time when a parent is deployed for active military service. If the parents cannot agree to custody and parent time during arrangements that involve deployment, state law provides guidelines. If the parties cannot agree upon legal and physical child custody orders and/or provisions for parent time, the parties may request a custody evaluation be performed by a professional evaluator, known appropriately as a custody evaluator. Although the judge or commissioner in your case can order a custody evaluation even without a motion from a party, most custody evaluations are ordered only if one or both parents request one. A custody evaluation may be expensive, and the cost is often divided between the parties. Parents who need help resolving conflicts about parenting issues may ask the court to appoint a parent coordinator. The services of a parent coordinator may be ordered by the court with or without the stipulation of both parties. A parent coordinator is a mental health professional who has expertise in child development and who helps parents resolve their differences by offering advice about the needs of the children and the workability of various parenting plans. The parents are not obligated to take the advice offered, and the discussions and recommendations are confidential. All parties to a divorce or child custody action must obey the court's orders. Custodial parents may not withhold parent time even if child support is not being paid. A parent may not withhold child support even if parent time is being denied. If a party does not obey a court order, the other party may file a motion asking the court to enforce the order. The enforcement order can include a judgment for money owed or extra parent time. The court may also find a party in contempt of court and order the party to pay a fine or to serve time in jail. You can also ask the court to award you your attorney's fees incurred for having to hire an attorney to help you enforce the court's orders against your ex. Either party may petition or in some cases move the court to modify a custody order or a parent time order if there are substantial material changes in circumstances since the order was issued and if the modification would be in the best interest of the children. Before a child custody and/or child support order from another state can be enforced or modified, it must first be registered in the state of Utah. For those of you who stuck through this video from start to finish, thank you for your time, and I hope you feel you've been richly rewarded.